Welcome back to the Constitutional Clarion. The recent conviction of Marine Le Pen in France, which excludes her from running in French elections for 5 years, and the forthcoming Commonwealth election have prompted viewers and the media to ask whether conviction of a criminal offence prevents a person from standing for office in Australia. There's a deal of confusion about this. I once sat next to a former politician at a dinner, and they confessed that they had invalidly sat in Parliament for many years because they had previously been convicted of a criminal offence. They seemed quite disappointed when I told them that they really hadn't been disqualified at all because they had served their sentence before being elected. I even had to pull out my phone and show them the constitutional provision in order to convince them that I was right. I think they rather liked the idea of having got away with it and were quite deflated to know that they were actually really just an ordinary undisqualified MP. So let's look at the law and the Constitution. Conviction affects membership of Parliament at the Commonwealth level in 3 different contexts: qualification, disqualification, and the commission of certain political offences. Starting with qualification, Section 34 of the Constitution sets out the qualifications to be a Member of Parliament, but it says until Parliament otherwise provides. So it was only a transitional or a temporary provision. Parliament has now provided in Section 163 of the Commonwealth Electoral Act of 1918. It says that a person who is 18 years or over, an Australian citizen, and either an elector entitled to vote at a House of Representatives election or qualified to become such an elector, is qualified to be elected as a member of the Commonwealth Parliament. This means that qualification then turns upon entitlement to enrol and vote, and that is found in Section 93 of the Commonwealth Electoral Act. It also deals with age and citizenship. However, a person is excluded from entitlement to enrol or vote if the person has been convicted of treason or treachery and has not been pardoned, or if the person is serving a sentence of imprisonment of 3 years or longer. Those of you who are law students who are watching will know that that was because of the Roach case in the High Court. A sentence of imprisonment is also defined in the Electoral Act so that it means that the person is serving a sentence of detention on a full-time basis for conviction of an offence against a Commonwealth, state or territory law. It does not apply where the person has been released, on parole for example, or is otherwise serving their sentence in the community. If a person is not entitled to vote because he or she is serving such a sentence or has been convicted of treason or treachery, then the person is not qualified to stand for Parliament. Now, I should add here, for those of my viewers who quite liberally spread accusations of treason, which of course have no relationship whatsoever with the actual offence of treason, we're only talking here about conviction of the real criminal offence of treason by a court that's recognised by Chapter 3 of the Constitution, not the made-up kind. Okay. Now, next we come to the issue of disqualification. The disqualification provisions are set out in the infamous Section 44 of the Constitution. They do not allow Parliament to otherwise provide, like the qualification provisions do, so the only way they can be changed is by way of a referendum. My Australian viewers will no doubt remember the great controversy that concerned the dual citizenship of a number of members and senators, which resulted in their disqualification some years back. But there are, of course, other parts of Section 44 of the Constitution which can also lead to a person's disqualification. Section 44(2) of the Constitution, for example, provides that if a person is attainted of treason or has been convicted and is under sentence or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer, then he or she shall be incapable of being chosen or of sitting as a senator or member. Now, first, apart from the treason bit, it only applies while a person is under sentence or subject to be sentenced. Just because a person has been convicted and sentenced in the past does not disqualify them from Parliament once they have actually served that sentence. Secondly, the key criterion is whether the offence of which the person has been convicted is punishable by imprisonment for 1 year or longer. It doesn't matter what the actual sentence is, or whether it's shorter or longer than 1 year. What matters is that the offence permits a maximum sentence of at least 1 year's imprisonment. There are also some tricky timing issues that apply to Section 44 of the Constitution. The High Court previously held in a case called Sykes and Cleary that the part of Section 44 which refers to a person being incapable of being chosen as a senator or member refers not to a particular moment, there's not some great ta-da, this is a second that you are chosen, but rather to the entire election process, from the point of nomination to the return of the writs. Now, what if you were disqualified at one point within that period, but not in other points of that period? What if you were disqualified during the period, but that disqualification was later overturned? You can see it could get quite messy. The most recent case concerning disqualification based on conviction was that of Rodney Cullerton. Cullerton was convicted of larceny on the 2nd of March 2016 in his absence in the Armidale local court for taking the key of a tow truck driver who was attempting to repossess a vehicle. The maximum sentence for larceny applicable in the local court was 2 years, so the offence qualified. As Cullerton didn't appear, he wasn't sentenced, but he was convicted and he was therefore subject to be sentenced. A warrant was issued for his arrest to bring him before the court for sentencing. 2 weeks later, the election writs were issued for the double dissolution election, which was held on the 2nd of July 2016. Cullerton stood for election as the One Nation candidate for Western Australia and was elected. On the 8th of August, Cullerton was granted an annulment of the conviction under Section 8 of the Crimes Appeal and Review Act 2001 of New South Wales. On the 25th of October, he pleaded guilty to an offence against Section 117 of the Crimes Act, but the court dismissed the charge without proceeding to conviction under a provision that permits the court to do this when it's satisfied that it's inexpedient to inflict any punishment on the person. He was ordered to pay compensation to the complainant. On the 8th of November 2016, the Senate referred to the Court of Disputed Returns the question of whether he was invalidly elected because of Section 44(2) of the Constitution. 5 judges sat in the case. The case was called Re Cullerton No. 2, 2017. Now, all 5 judges unanimously held that Cullerton had been invalidly elected. 4 of the judges noted that in Sykes and Cleary, the High Court had applied the Section 44 disqualification to the whole of the process of being chosen, from nomination to the return of the writs. They observed, however, that in this case, no question arose as to the temporal operation of Section 44(2) because Cullerton's conviction applied throughout the entirety of that period. Difficulties might have arisen if the annulment of his conviction had occurred partway through that period, but it didn't. Their Honours also noted that the Commonwealth Attorney-General had made two submissions. There was a broad one, which was that Section 44(2) applied to a person who was convicted and liable to be sentenced during that entire period, election period, regardless of whether or not the conviction was later nullified with retrospective effect. The narrow submission was that in this particular case, the annulment only had a prospective effect from the date of the annulment and therefore did not affect the application of Section 44(2). Their Honours concluded that as this narrow submission was correct, it was unnecessary for them to consider whether the broader submission was correct as well. They observed that an annulment may operate retrospectively or prospectively, depending on its statutory context. In this case, Section 10, subsection 1 of the Crimes Appeal and Review Act provides that on being annulled, a conviction ceases to have effect and any enforcement action previously taken is to be reversed. They concluded that the annulment did not expunge the legal rights and obligations arising from the conviction, save in relation to the future and in the reversal of things done under it. The conviction was only annulled for the future. The provision did not operate to deny legal effect to a conviction from the time it was recorded. Hence, at the time of the process of his election, a conviction was recorded against Cullerton and he was subject to being sentenced, and this was not altered by the annulment. Finally, there are some criminal offences which are concerned with the corruption of elections or the exercise of undue influence in relation to them. In those cases, the punishment includes exclusion from being able to run for Parliament for a period of time. Section 386 of the Commonwealth Electoral Act 1918 provides that if a person is convicted of the offences of election bribery or interference with the political liberty of a person, or is found by the Court of Disputed Returns to have committed or attempted to commit bribery or undue influence when a candidate, he or she shall be incapable of being chosen or sitting as a member of either House of Parliament for a period of 2 years from the date of conviction. The validity of these offences has not been challenged because they haven't actually really been used, but it would actually raise some quite interesting questions of whether Parliament has the power to disqualify people in this manner, or whether such a law is invalid for going beyond the disqualification set out in Section 44 of the Constitution. We really don't know unless the provision is used and then challenged. Thank you once again for watching the Constitutional Clarion. I hope this helped, especially for those of you who might be considering standing for Parliament at the forthcoming election. I would strongly recommend paying very close attention to the various disqualifications in Section 44 before nominating, and that includes not only the citizenship issue, but rather tricky ones concerning things like office of profit under the Crown and having a pecuniary interest in an agreement with the public service. There are plenty of heffalump traps lurking in Section 44 for the unwary. So good luck if you are intending to stand for Parliament, and as always, I look forward to seeing you again next time. Goodbye.